Today I'm going to talk about long-term disability claims. Hi everybody, I'm Troy Rosasco and I'm with Turley, Redmond, and Rosasco. We are long-term disability lawyers in New York. There basically are two types of long-term disability claims. First, you've got group long-term disability claims that you might get through your employer or an association you might belong to. So for instance, a lawyer like me might get long-term disability through his local bar association. If you're an accountant, you might get it through your accounting association. Very different than a person who gets a disability income policy through a private insurance company. I know myself, I've got a private disability insurance policy through a very well-known insurance company. Let's talk about the group disability policies first. That's where most of the problems come in for most people. When you have a group disability policy, generally they require that you prove that you're disabled from your own occupation for the first 24 months that you're out. And then they require that you be disabled from any and all occupations after the first 24 months. In addition, most group policies will limit benefits for mental and nervous conditions also to 24 months no matter what. Therefore, at the end of the day, those group policies many times try to cut your benefits after 24 months. Well, what if you've also subsequently been approved for Social Security disability? And Social Security disability requires that you be disabled from any and all occupations. Will the insurance company, the long-term insurance company, agree with Social Security? Unfortunately, no. They claim that they're not bound by the Social Security Administration. And you know what? The law that governs long-term disability group claims is a law called ERISA, the Employee Retirement Income Security Act of 1974. And it's no great shakes for injured and disabled workers. So that is much more favorable to insurance companies. When you have a claim like this, the best advice I can give you is to get a lawyer involved earlier in the process. Do not wait until you've been turned down. By that time, it may be too late. I'm not trying to encourage business here, but I'm just trying to give you the best advice I know of. Get a lawyer involved so that the lawyer can get all the medical evidence together so that you can put in your best foot forward at the beginning of the claim. Regarding the private disability policies, they're a lot better. Why? Because if you get turned down, guess what? You're allowed to go to the New York State Supreme Court and sue the insurance company, unlike the group policies. You get a jury of your peers. Can you imagine you having paid a policy premium for a number of years? God forbid you had a heart attack and you couldn't continue working, and then the insurance company is sitting on the other side, not just some plaintiff, the insurance company is sitting on the other side, okay? Who's that jury going to side with? You, the person paying premiums who had the heart attack, or the insurance company? I bet you know the answer. Why am I telling you this? Because you have questions and I have answers for you. My name is Troy Rosasco. If you have questions, please call me at 1-877-NYDB-LAW. If you found this video to be helpful, please press the like button below this video so that you can share this helpful information with all your friends on Facebook and YouTube. Thank you.